Assalamualaikum, ladies and gentlemen. Welcome to the 31st session of İSAM Scholarly Talk Series. Today we listen Professor Stephen Collis from University of Texas at Austin School of Law, where he served as clinical professor of law and founding director of Beck Laughlin First Amendment Center. His research and writing focus on religious liberty and constitutional law, and he is the author of several books, including Deep Conviction and Habits of Peacemaker. The moderator of this session is Assistant Professor Sami Ayub, also from University of Texas at Austin. Dr. Ayub specialized in Islamic law and comparative legal traditions, and he is the author of Law, Empire and the Sultan, Ottoman Imperial Authority and Late Hanefi Jurisprudence. We are delighted to welcome both distinguished scholars to İSAM. Professor.
Thank you.
Of course. Yeah. So I guess the
Okay. Well, thank you so much for having me here. I apologize that I only speak English. Sorry for that. But I'm just thrilled to be here. This is my first time in Turkey and my first time in Istanbul, and I have very much enjoyed learning about this wonderful city and land. And I'm very grateful for Professor Ayub for putting up with me and for giving me a tour of a number of different destinations. The focus of my talk today is going to be on largely how the United States has dealt with questions of religious liberty, and in particular balancing competing interests of different religions as well as secular interests versus religion. So I'm going to give a little bit of the history that led to the founding of the United States in terms of how we started thinking about religious liberty the way we did. And then I will jump into showing the history in the United States and some of the specifics of where the law is today. And then I welcome any questions afterwards and look forward to a robust discussion. I've actually seen, in talking with Professor Ayub, many parallels between Turkey and the Ottoman Empire and things that happened in the United States with Christianity. So I look forward to this discussion. The story really begins prior to 1517 in Western Europe, where pretty much anyone who was thinking about religion was Catholic, and there really was no category that we call religion. In other words, there really wasn't any difference between religion and secular thinking, because everything was dominated by the Catholic Church, and that was kind of the universal way of thinking. But during the 1400s and moving into the 1500s, there were pockets of people who started to protest and had disagreements with the practices and teachings of the Catholic Church. And those groups really did not gain any power until the invention of the printing press. And then, so you had small pockets of people writing against the teachings of the Catholic Church, but they couldn't join forces until Gutenberg invented the printing press. And then as these ideas started to get published, groups of people started to form to protest the Catholic Church, which is where we get the term Protestant Christian. It comes from the word protest, Protestant. And what happened was the Protestant Reformation, starting in the mid-1500s, resulted in different groups of Protestants rebelling against the Catholic Church. That resulted in the Catholic Church trying to suppress the Protestants, usually using force. So as Protestants spread throughout Western Europe, the Catholic Church tried to suppress them, and then Protestants and Catholics engaged in power struggles for control of government. So what that resulted in was about 250 years of religious warfare. We refer to these as the religion wars. Just to give you a couple of examples, this is an artist's rendering of the French wars of religion, where Protestants and Catholics fought with one another for control of government and then wanted to use the power of government to oppress each other. So Protestants would get control and oppress Catholics, and then Catholics would get control and oppress Protestants, and then Protestants would get control again and oppress Catholics, and it was a cycle. During the French Wars of Religion, it is estimated that 20% of the French population was killed. Of course, these wars were complex. It wasn't just about religion, but that was one of the main driving factors. Another war that's very common is, during the religion wars is referred to as the 30 Years' War. Same thing, Protestants, Catholics fighting for control of government, and then once they get it, trying to force religious unity on the populations. All of this has led to many people to think that the problem was religion. So you get this type of thinking is very common in the United States. If you look at this cartoon, you have war thanking religion, basically, right? And many people began to think that it was religion that led to warfare. But it turns out that that's wrong. What was leading to the warfare was a lack of religious liberty, a lack of law that would allow different religions to thrive alongside one another in the same society. And so what the religion wars led to first in Western Europe and then in the colonies that became the United States, the war led to the development of religious freedom. So I've put together a little thing here where you can see you have new religious ideas emerge. They're coupled with technology. So then you get new religious beliefs that come out, old religious beliefs that come out. That led to religious warfare, and that eventually led to thinking about religious freedom. The first idea of religious freedom that developed, and it developed first in England. Well, let me back up. There were some notions of religious freedom that developed before any type of philosophy developed, just out of practicality. So what is now Poland, for example, had pretty robust religious freedom between Protestants and Catholics because they figured that was a way to strengthen themselves against external enemies. But the first philosophical thinkers, a lot of it came from people like John Locke, who started arguing for what we call tolerance. The idea was there could be a favored religion in any given country, but they must be tolerant of other religions. That idea came first. So protecting other religions and minority religions came first. Later, there developed the idea that there could not be a favored religion from the state. So that came later, even after the founding of the United States. But those two ideas found their way into the United States Constitution in our First Amendment. These are the two primary religion clauses in the United States Constitution. The one in red is called the Establishment Clause. Congress shall make no law respecting an establishment of religion. Establishment of religion is a legal term of art. It is not referring to a religion that has been established, but it is referring to a state church. So a government-sponsored church. That's what that's referring to. And then the other clause, Congress shall make no law prohibiting the free exercise of religion. That's the idea that people should be protected in how they live out their religious beliefs. And it's these two ideas working together largely that form religious freedom in the United States and how we think about it. Protecting the free exercise of religion is one column, and the idea in theory is that all people should be able to live according to their religious beliefs, or not, and not be forced to act or not act according to their religious beliefs to some degree. And then on the other hand, government should not be favoring one religion over another. And what I'm going to talk about first is how the United States historically treated protecting the free exercise of religion. And then I'll jump to explaining how historically the United States put in place protecting against having a state religion. As many of you probably know, the United States has a written constitution, and that governs over all other laws. We also follow a common law system. So the written constitution gets interpreted by the United States Supreme Court, and that determines what the Constitution means over time and how it must be applied. So each of these clauses get interpreted by the court, and then that's what rules in the United States. Here's the timeline of how the United States Constitution has protected religious liberty, and specifically the free exercise of religion. You will note from the founding of the United States in the late 1700s all the way until the 1940s, the United States really did not do a very good job of protecting the free exercise of religion, especially for minorities. So during this period of time, throughout the 19th century and the first half of the 20th century, religious minorities especially really did suffer. And those religious minorities who were able to thrive only because they were able to move somewhere else. So for example, the Amish often were oppressed in the United States, and they would simply move to another region. And then when government would come down on them, they would move to another region. The Church of Jesus Christ of Latter-day Saints, also known as Mormons, they faced significant oppression, and they moved from New York to Ohio, to Missouri, to Illinois, and then eventually across the entire continent to what is now Utah, to get away because there was no protection for the free exercise of religion. So until the 1940s, many religious minorities really suffered. The groups that probably suffered the most were indigenous Native Americans. Many of their religions really struggled during this period, and some were almost nearly wiped out. In the 1940s, the U.S. Supreme Court started to apply the free exercise clause of the Constitution to all levels of government. And so for the first time, courts started taking it very seriously, protecting the free exercise of religion. And they developed a test that in the United States we call strict scrutiny. Another term for it is the compelling interest test. But what the Supreme Court said was, if government at any level burdens a person's religious exercise, government must prove that it has a compelling interest for doing so, and that it has taken the most narrow means possible to achieve that interest. So that was the test that the United States Supreme Court developed during this green period of my timeline here. So from about the 1940s to 1990. To give you an example of the compelling interest test, I'll make a really simple example. Imagine if my religious beliefs required me to sacrifice a 12-year-old boy to the gods once a year. So imagine that. Because we have a language barrier here, I want to be very clear. That is not my religious belief. Let's just imagine, okay? I think everyone would agree that the government would have a compelling interest in stopping me from sacrificing a 12-year-old boy to the gods. So government would have a compelling interest, but it also would have to take the most narrow means possible to achieve that interest. So that means it can't, for example, blow up my church or arrest all the members of my religion, or seize all the assets of my religion. It can't do those things. All things various governments have tried throughout United States history. But maybe it could have a police officer monitor me on the day that I might want to sacrifice the 12-year-old boy to the gods, right? The point is, it has to take the most narrow means possible to reach its compelling interest. So that was the test that was in place. And it largely worked in the United States. In fact, it's during this period from the 1940s until today that we had a massive explosion of religious diversity in the United States. Almost every religion on earth is now represented in the United States, and largely it's because this free exercise of religion was protected. But then, in 1990, the Supreme Court changed its mind. It went a different direction. And it said that actually people had been misunderstanding its previous rulings for the last 50 years. And it came up with a new test. The new test was, now remember, this is all about what does the free exercise clause mean? That's what the court is interpreting. The new test is if a law is neutral and generally applicable, then it does not matter if the law happens to burden someone's religious exercise. Does that make sense? So this new test could have been devastating for religious liberty, and it caused a massive uproar in the United States. The entire political spectrum was upset about this decision. The decision was made in a case called Employment Division versus Smith, and it was the conservative wing of the U.S. Supreme Court who made this ruling. Think about what that test means. So the test is if a law is neutral and generally applicable, it does not matter if the law burdens someone's religious exercise. So in the United States, we have a large number of Catholics. Catholics use wine in their Catholic Mass. If government were to pass a law forbidding the sale, use, or transport of any alcohol across the country, that would mean that Catholics could not celebrate Mass, and they would have no argument against it. Okay, so the central religious practice of their religion they could not practice. That caused a huge backlash. The Supreme Court has not changed that opinion, but what has happened over the last 35 years is the Supreme Court has slowly interpreted the words neutral and generally applicable to mean that there is almost no law that government can pass that will actually be neutral or generally applicable. And what that means then is if a law is not neutral or generally applicable, the government has to pass the compelling interest test. And once again, we're back to where we were between the 1940s and 1990. So to summarize where we are, I'll put the kind of where we are, just where the black letter law is today. Government, generally, if it's going to burden religious exercise, it has to prove that it's taken the most narrow, it has a compelling interest, and it's taken the most narrow means of achieving that interest. In other cases, if the government can prove that the law is neutral and generally applicable, then it does not have to show that it has a compelling interest and will probably win. Here's the challenge, though. A law is not neutral if it targets a particular religion. So, for example, in the state of Texas, right now, the government is doing all sorts of things that it appears as if it is targeting Muslims. There are large Muslim populations who are trying to build various communities and mosques, and the state of Texas is intentionally doing things to prevent these Muslims from doing that. That is likely not neutral. So if the Muslims bring a lawsuit to stop the state of Texas, that's what their lawyers are going to argue, that this is not neutral, and we'll see if they can win on that. The bigger problem for government is trying to prove that a law is not generally applicable. So when the Supreme Court in 1990 said if a law is generally applicable, then it doesn't matter if it burdens religious exercise, everybody thought that most laws were generally applicable. What the Supreme Court has said is if government passes a law, but it has any type of exception to that law for secular interests, that law is not generally applicable. Even one exception to a law can make it not generally applicable. So to give you another example involving Muslims, there was a police department in Newark, New Jersey, and it had a law, it had a rule that all police officers needed to shave their facial hair. Okay, that was its rule. And the government claimed that it wanted this rule because it wanted all police officers to have a uniform, clean look. Okay, there were two exceptions to the rule. One exception was for medical interests. Some people, if they shave, it causes severe rashes and problems. And so there was an exception to the rule for medical interests. And two Muslim men came and they interpreted Islam. I joke with Sammy that if there's 1.2 billion Muslims on earth, there's probably 1.2 billion opinions about what the religion requires. But these two Muslim men felt like their religion would not allow them to shave. So they asked for a free exercise exception to the rule. And the police department said no. So they brought a lawsuit and they said this law is not generally applicable because you've made the medical exception. And the court held that's right. Even one exception for the medical reason makes the law not generally applicable. Therefore, the police department was forced to allow the Muslim men to grow beards as well. Okay? The government could not value a medical reason over the religious reason. That's the theory behind that. Okay? The court has also held that if there is a law or regulation that allows government to have discretion over whether or not it applies, that is not generally applicable. So I don't know what an example would be in Turkey, but in the United States, we have all sorts of rules that only apply if a government official feels like applying them. My screen went off. That's okay.
HDMI kesin seç abi.
I need to be moving through my slides fast. Thank you. So you can imagine a world where there's a law, but it gives a government official discretion about how to apply the law. And in those scenarios, those are not generally applicable either. So when you take those two ideas together, it turns out that pretty much any law passed in the United States is not going to be generally applicable. There are always exceptions. There's always government discretion. And so generally where we are now is that if government burdens someone's ability to exercise their religious beliefs, most likely government has to pass the compelling interest test. Does that all make sense on the free exercise part? So then there's the establishment clause. Congress shall make no law respecting an establishment of religion. I will be honest with you, we have never had any idea what this clause means. It is, if you think the law protecting free exercise of religion is a mess, this is worse. I'll give you another timeline. Part of the problem is the text itself. So if you look at the text, Congress shall make no law respecting an establishment of religion. It's not very clear, right? It doesn't say Congress shall not create an establishment of religion. It doesn't say that. At the time of its passing, there were actually state establishments of religion. So we still had, at the time that this was put into place, at least 3 very vibrant state churches in 3 of the states that were the original 13 states in the United States. The argument sometimes is made that what this was meant to do was prevent the original federal government from interfering with the existing state establishments. Okay? But that is not what the Supreme Court said. What the Supreme Court said was, first off, it doesn't apply to the states again until the 1940s. So from 1791 to 1947, the Establishment Clause did not prevent the states from creating their own state churches. Some of these existed until 1838, when the last one was abolished voluntarily, not forced by law. Okay? Then we get to 1947, and a school district wants to start paying money to allow for children to receive free busing to a private religious school. Government money to a private religious school. And the question became, does this violate the Establishment Clause? So the Supreme Court ruled that 1, the Establishment Clause applies to the states, and then it said 2, that particular program does not violate the Establishment Clause. The problem was that the Supreme Court had absolutely no theory about what the Establishment Clause meant. So it started on a journey for the next 60 years of trying to figure out what the Establishment Clause meant. And it went down probably 20 different paths. It gave us all sorts of rules. In some decisions, it said government may not coerce religion on people. In other decisions, the Supreme Court said government could not endorse one religion over another. In some cases, it said government could fund religion, could give money to religious institutions. In other cases, the Supreme Court said government could not give money to religious institutions. In 1971, it issued an opinion called Lemon v. Kurtzman, where it tried to finally come up with a theory of what the Establishment Clause meant. And that case did nothing but cause confusion for 50 years. It was internally inconsistent, and it was so malleable that lower courts were able to basically reach any outcome they wanted at any given time. So it was a real mess. Okay. In 2017, the court started to offer some clarity about what the Establishment Clause meant. It offered some more clarity in 2019, moving towards 2025. And finally, in 2022, it basically got rid of all of the past law, but it didn't really give much clarity for going forward. So I'm going to tell you now where we are with the Establishment Clause law, and then we'll jump into the next thing. So here's some things we do know. The government may give aid to religious institutions, so it may give money to religious institutions, but it has to be on a neutral basis. Government cannot discriminate in favor of any one religion or religious group. It cannot discriminate in favor of religion, and it cannot discriminate against religion in favor of secular institutions. So where this has come up is a lot of the states want to give money to private schools. The states were wanting to give money to private religious schools, but not to private secular schools, but not to private religious schools. And the Supreme Court, in a series of cases, has said you can't do that. If you're going to give money to private schools, you have to give money to secular schools and religious schools on the same terms. Okay, so that's clear now. We have in the United States a lot of government-owned land. In fact, most of the western United States is referred to as the public lands states because the federal government owns most of the land. And it's usually open for anybody to go and camping and play on, or preserving natural wonders, that kind of a thing. If there are religious symbols on government-owned land, and they have been there historically for a long time, we now know that government is not required to take them down. Does that make sense? So here, what happened was there were crosses and things, Christian crosses on government-owned land, and various groups challenged the existence of those crosses and claimed that, and made the arguments that they violated the Establishment Clause. The Supreme Court ruled to take these religious symbols down now would appear to be hostile toward religion in favor of the secular. So we're going to allow historical religious monuments on government-owned land to remain. That offered absolutely no clarity about what to do about new religious things that might appear on government-owned land. But at least we know historical things get to stay and are not a violation of the Establishment Clause. We also know a few other things. Government may not, quote, and this is from a recent Supreme Court opinion, it may not do things that violate the, quote, historical principles and understandings of the Establishment Clause. Nobody knows what this means. It means that if we're trying to figure out if government has done something that violates the Establishment Clause, we have to go back in time and figure out what was an establishment of religion in 1790, and is what government is doing now similar to that? But to be honest with you, I think it will take about 30 to 40 years to figure out what this means. There's going to be a lot of litigation going up to the Supreme Court to clarify this. The one rule we know from this is that government may not coerce religion upon people. So where this comes up the most in the United States is in our public schools. A teacher with a captive audience of students in a public school may not preach religion to them. We have had cases where teachers might force students to read a certain version of the Bible. That would not be allowed under this test. Or if a teacher in a public school tried to lead a classroom of students in prayer, that would not be allowed under this test. That would be considered coercing religion upon public school students. It is tempting to think that the people who do not want religious prayer in schools are people who have secular interests. But actually, oftentimes, the people who bring the claims against these types of practices are actually very devout people of other religions. So, for example, there was a case again, out of Texas. Texas, by the way, is the gift that keeps on giving for violating religious freedom. But there was another case out of Texas where a school district was trying to force students to read a Baptist version of the Bible and engage in Baptist prayers. And if students didn't do it, they were punished. 2 families brought a lawsuit challenging the practice. These were not secular families. They were a very devout Latter-day Saint family and a very devout Catholic family. And what they didn't want was another religion being coerced upon their children in public school. So they brought this lawsuit. The question that we don't know is, other than coercion, what else does the Establishment Clause forbid? That's something that is going to be tested out over the next 30 or 40 years as litigants bring this test, this historical principles and understandings test, and the Supreme Court will decide if other principles apply. All that makes sense about the Establishment Clause?
Yes.
So it's really confusing right now in the United States. If you're a government official, you're often walking on eggshells because it's not clear what does and does not violate the Establishment Clause. There's a few other things, a few other instances in the United States where both of the religion clauses are working together. So this is probably where religious freedom is at its maximum in the United States. One is government may not interfere with the employment of ministers or clergy or imams or any type of religious clergy. Government may not interfere with that except in the most exceptional cases, such as if there's evidence of child abuse happening. Okay, so employment laws that prevent discrimination in employment that apply to most employers in the United States do not apply to religious institutions if you're dealing with religious leaders. Okay, those are protected completely from the Constitution, by the Constitution. A similar doctrine is something we call the church autonomy doctrine, and it's the idea that when religions are dealing with ecclesiastical matters at the heart of religion, theological decisions, government may not interfere in any way. To give you an example, there was a case recently where somebody sued a religion trying to claim that the way the religion defined tithing was basically wrong. And the judges applied the church autonomy doctrine and said, we are not allowed to get into this theological question of what constitutes tithing. The religion gets to choose that, not judges, not the law. So they get total protection for religion there. And then finally, sometimes in the United States, there are various property disputes related to religion. So imagine a hierarchical religious organization where you have a global church and then a local branch of that church. And the local branch decides to break free from the global church. And they want to take the building with them. Well, some of these buildings are historic. They're in major metro areas, and they can be worth hundreds of millions of dollars. And the local group wants to take it. The global church says, no, that belongs to us. You can leave, but you don't get to take the building. And if there's a lawsuit there, what the Supreme Court says is courts can decide those disputes, but they have to use neutral principles of property law. They cannot use things like looking into who is most consistent with the shared theology of the religion or who is deviating from the religion, things like that. They cannot look into any of that. And they generally do not feel like they have to defer to the religious tradition to determine who gets the property. They feel like they can decide it using neutral principles of law. Lastly, for a country that brags as much as the United States does about religious freedom, we have absolutely no definition of the word religion. We've never been able to define it. We know it can't be obvious formal religions. It can't be limited to just that. We also know it can't be every human philosophy. It's somewhere in between. But the problem is every time someone tries to define the word religion for the Constitution, you end up almost always either leaving someone out that obviously should belong, or you end up including people that should obviously be left out. So what the courts have done is they've really just never tried to define the word. And when claims are brought, they just assume they're dealing with religion, and then they find some other way to get rid of the case. They've kind of just avoided the question. The most agreed upon definition of religion that most people tend to think is probably the only one that would work is what we call the analogical approach. And that's to take what everyone agrees is a religion, try to figure out its characteristics, and apply it to whatever new practice is coming before a court. But that's more in the academic discourse and less in the case law. Lastly, there's a huge question about theory versus practice in the United States. So everything I just spoke about is the theory, right? Now there's the question of how does it actually play out on the ground? And the driving force in this goes all the way back to the Puritans. So this is a statue of a Puritan. Many of you probably know, or maybe you don't, some of the first people to settle in North America were the Puritans from Europe. And we often like to say that the Puritans came to North America for religious freedom. And it's true they did, but they came only for religious freedom for themselves. They weren't interested in religious freedom for anybody else. And we refer to that as the Puritan mistake. Okay? The Puritan mistake drives most of what happens for religious liberty law in the United States. And what I mean by that is, we scholars who use the term Puritan mistake are picking on the poor Puritans. But in my experience throughout US history, pretty much every single group has been guilty of committing the Puritan mistake. I can't think of a religious group that has not been guilty of it at one time or another, and that includes atheists and agnostics. Okay? So people tend to be in favor of protecting the free exercise of religion if doing so is consistent with their religious beliefs. They tend to be opposed to it if it's inconsistent with their religious beliefs. People tend to be opposed to the idea of establishment of religion unless it's their establishment of religion. Then they tend to be in favor of it. And we see this distorting the law constantly. So I'll go back again to my state of Texas where I live now. We have lawmakers who have done nothing but champion protecting the free exercise of religion for decades, right up until Muslims came and said that they wanted to build a mosque, and suddenly they have major concerns about the free exercise of religion, right? So we see this again and again and again throughout US history and even in modern times. I will say this, by and large, I think the protections for the free exercise of religion and the protection against an establishment of religion are working. Government officials try to comply with these things because they want to avoid lawsuits. Generally speaking, people are allowed to build religious buildings and mosques and other things. But it doesn't work perfectly because of the Puritan mistake. So we're doing well, but we could do a lot better. Certainly the practice does not always mirror the theory. So that is the history and current state of religious liberty law in the United States in a nutshell. And thank you for having me. I look forward to any questions.
Thank you. Okay, thanks so much, Professor Collis. And again, thanks for being here. We have some time to ask questions, have comments. Please state your name and go ahead and ask any questions. If it's in Turkish, so Mr. Hodja will have to translate. Yes, please.
Okay, my name is Şahin Uçar, Professor of History. I remember from the time of Reagan's administration. Do you remember those discussions about religious practices in schools? People were saying that how dare you to practice or preach some religious beliefs to our children. I read that, I guess from Time magazine. And I think this is always a problem for every government in history. And I would thank you for good presentation, but I would like to add some thoughts about semantics. Generally, scholars of law doesn't understand that you cannot define words by words. This is the saying of Hayakawa, semanticist. Maybe you know. American Senator Hayakawa, who wrote a book about language in thought and action. He was the student of Alfred Collis'in, again another semanticist. Alfred Collis'in said that map is not territory. So the words are not the things. they refer, okay? So you cannot define the words anyway. This makes every time problems in language about discussions, but particularly in lawsuits. So I think those preterm mistakes are unavoidable in every time and for every government. What do you think? What do you say about this?
Well, I agree with you that I think these mistakes, the Puritan mistake, will be unavoidable to some degree. And in my view, the question is, how can we minimize it? Your comments about words and being undefinable is probably the central dispute, as you know, I think, in the United States about constitutional law.
Yeah.
So we have one branch of scholars who argue that words matter, that the written text matters, that the written text should be controlling.
Definitely.
And we have other scholars who say, look, we cannot define these words. It's impossible to reach a consensus on what they mean, and therefore at best they are advisory, but we need to move forward without being constrained by the words.
Excuse me, that means you can apply those only approximately.
Only what?
Approximately.
Approximately.
Approximately, I mean.
Yeah. And that is the largest, probably the biggest ideological battle among U.S. legal scholars.
Yeah.
It's not unique to religious freedom law. It applies to all of constitutional law. And I find U.S. scholars are all over the map in terms of what they think about that. I don't know any scholars who, and certainly not judges, who, when trying to apply religious liberty law, don't start with the text. I mean, everyone starts with the text.
Yeah.
The question is, do they believe we should go and actually figure out the meaning of that text, or do they try to philosophize going forward? And that has been a debate for many, many, many years.
Yeah, because they are bound to the text, but the text is not understandable clearly for the most time. I don't think it is definable.
Right. Well, and many people disagree with you.
Yeah.
I am a little bit in the middle on that. I think some of it is, and oftentimes it's not. I will tell you though, in one of the most recent Supreme Court opinions, everyone thought the court was going to try to define the free exercise clause. And one of the key votes for doing that, her conclusion was she just didn't think we could find the original definition. She didn't think it was possible. And then the question becomes, well, where do we go from there? Whose theory do we use to apply this text? So,
Thank you.
Yeah.
Wonderful.
Thank you for this wonderful.
What's your name?
Yaşar Çolak, Vice President of this institution, and I have also served for about 7 years in the United States in an institution directly related to this kind of, topics or practices, and we attempted several times to establish a religious institution. Not only the mosque and the religious schools in the United States, and based on the constitutional rights related to the religious freedom and practice, we couldn't get the result because of the conflict, inner conflict between the theory and the practice. For instance, in New Jersey, as a non-profit organization, carrying out all the qualities of the requirements or governmental requirements to open an Islamic school in the United States, we applied to open a boarding school in New Jersey area. Good, which is quite legitimate for a non-profit organization to open an Islamic school. That's good. We applied. And the government put in front of us the neighborhood, the people living in this neighborhood. They say, you have to get the consent of the neighborhood living in that area. Okay, two-level, poll, or what do you call it, referendum. And we passed in the first, but in the second, all the people came together to oppose our own initiative or our own project, using some arguments against the freedom of religion. They say you are in intention of bringing Al-Qaeda, from Afghanistan to that region. We don't want this. We said we bought this, land. It was an old primary school and usable for the educational institutions. There is no any problem in getting the permit from the county, but they say you have to convince the people. But the people are opposing us because of their own religious bigotry. So that creates the problem. In theory, the United States of America seems to get the good lesson from the religious conflicts, historical religious conflicts, and created a kind of neutral system in the United States. But in reality, the minority groups, particularly Muslims, are facing this kind of, problems, which cannot help them using their own freedom of religion.
Yeah, I mean, you literally, that's the classic example of the Puritan mistake, right? I suspect that neighborhood would have had no problem whatsoever with, say, a Catholic school being built. But when people are biased against one religion, they don't respect the free exercise of religion. Now, let me ask you a question. What year was that?
Probably, if I'm not mistaken, 2013 or 14.
Okay, interesting.
Yeah.
So there is a massive problem in the United States with discrimination against religious groups in the land use context, trying to use land for religious purposes. So much so that in 2000, Congress was trying to pass a law related to religious freedom. And they couldn't agree on anything, which is typical. They couldn't agree on anything, but the one thing they agreed on was that there was massive discrimination like that in the land use context. And so they passed a law called the Religious Land Use and Institutionalized Persons Act. And it's supposed to stop that type of discrimination. But of course, to win, then a group has to file a lawsuit. You have to litigate that lawsuit for anywhere from 2 to 7, 8 years. And then eventually you win, and all the kids you were hoping to build the school for have graduated from high school and moved on. So it becomes a real problem in practice to enforce these laws. And that often happens where neighborhoods use their power over zoning and other things to prevent religious groups from building. Now, I don't want to paint a horrible picture of the United States. There are lots of Islamic schools. There are lots of mosques being built. There are plenty of neighborhoods where people don't discriminate and allow these things to be built. But when you do get a neighborhood like that, it becomes incredibly difficult.
And those kind of situations also vary too. It fluctuates. For instance, in the following days of 9/11 in New York, I was there quite some time. Some Muslim communities experienced similar difficulties in opening up Islamic schools.
Yep.
But later on, few years later, when the Islamophobia somehow lightened up, loosened to a certain extent, then those kind of initiatives became possible. Those are the temporal fluctuations, I could say.
Yeah. And as our good scholar here said, right, you can only approximate trying to actually apply these laws. We regularly see situations where if the law were applied perfectly, the religious claimant should win, but it's very difficult to get to the law applied perfectly on a consistent basis, right?
Right.
So,
Is the question?
there's a question.
Is there any degrees of
Puritan mistakes to according to other religions. Some more to the Muslims, or less for the Hindus, like that.
So, like, is one religion more prone to committing it than another? So, I don't have any hard empirical proof for what I'm about to say, but in my experience, it tends to be whoever has the most power in a given region tends to be the one most likely to commit the Puritan mistake. So, and I see this globally, it's not just in the United States, right? I see that again and again and again. And you see it, to give you a sense of this, in the United States, it used to be that conservative Christians were the ones who were opposed to religious freedom. This is back in prior to the 1990s. Conservative Christians were opposed to religious freedom because what did it mean? It meant it was going to protect religious minorities, and they weren't interested in doing that. Well, then in the 1990s, we started to have a pretty dramatic shift in the United States. Oh, and I should add, secular liberals were very much in favor of religious freedom. Then in the 1990s, we had this culture shift where conservative Christians kind of became a cultural minority and secular liberals became a more cultural majority. Now, conservative Christians are way in favor of religious freedom and secular liberals hate it. It's a complete shift. The political parties have shifted, everyone. Unless within a given community they have the power, then they switch again. So my experience has been it takes a very rare group of people to have power and to not commit the Puritan mistake. It's very difficult to do. I think some do it, but I think it's very difficult to do. The Church of Jesus Christ of Latter-day Saints in Utah really prides itself on trying not to commit the Puritan mistake. I think the same with some Amish communities, but it's difficult for groups not to do it.
I asked them, especially for example, there is any activities in favor of some of the Jews, for example, like that. They embrace some of the old doings of themselves, and now they doing some less Puritan mistakes to them.
Well, even Jewish populations in the United States are guilty of this, and of course, I don't want to get into the Israel-Palestine conflict, which is so much more complicated than just about religion. But take the eastern seaboard of the United States, where that's where most Jews in the United States are on the eastern seaboard.
Yeah.
Many of them, of course, are secular; they're not religious Jews, right? But there have been cases, for example, where government engaged in certain behavior to favor especially Orthodox Jews in a way, because of their Sabbath observance, they could only walk so far on Sabbath, that kind of a thing. So they organized like whole city governments in a way to favor them, and there were cases brought to challenge that because it was at the expense of other religious groups. And so we see that also playing out in the United States. Again, it can be even neighborhood specific.
Yeah.
It can be neighborhood specific in the United States in that same way. Certainly city specific.
Yeah, that was like the same thing, especially in the South Asian countries, India, Pakistan, and Bangladesh. Even we see these things not within intra-religion, intra-faith, like with a sectarian level, and even in tennis levels, we face these things. So, is it just a Puritan mistake or something like an human psychology? Like,
I think it's human psychology, and in fact, the scholar who came up with the term Puritan mistake, I asked him why he picked on the poor Puritans. Because I said, it just seems to me that every human group, commits this. And he said, well, I was writing for Americans and it sounded erudite. sounded intelligent to say the Puritan mistake, because we always say the Puritans came for religious freedom. I also don't think saying the human mistake sounds very intelligent, but the reality is I think it is the human mistake, right? And we see it again. And it really does distort the law in ways that can be unfortunate. So, yeah.
Thank you for the presentation. I have a couple of questions, but I'll sum it up as much as I could. So, as I understand, U.S. courts often speak of church autonomy as a constitutional doctrine. Do you think this concept equally covers non-Christian denominations, institutions? Is there such thing that is in the law coming up as mosque autonomy?
Yeah. Should I answer that real fast?
As you like.
Yeah, let me answer that real quick.
Sure.
So the answer is yes. The reason we use the phrase church autonomy is because originally when the lower courts were developing it, it was only Christian churches who were bringing the claim. But, and so that term is not an inclusive term, but it is inclusive in how it's applied, if that makes sense.
So it's kind of an outdated term, including all the religious things.
Yes.
Correct. You might think of it as the religious institution's autonomy, right? If a government tried to come in and force a mosque to interfere with a mosque's or an imam's teachings or something specific to their theology, the mosque could bring a church autonomy claim just as a church could. So it applies to every religious institution.
Okay, the second question is a little bit historical perspective in the note with regards to locking definition. We were talking about tolerance, I think. So would that also refer to the notation of the very post-Reformation term in the Latin sense, which means in the Latin sense to uplift or bear with some kind of burden? Or does this refer to an idea of understanding with the affection and sympathy to the other religious institutions? How would you draw a line between the two meanings? The way we use today in the semantic sense of understanding someone as an interfaith dialogue, or is it kind of tolerating based on real politics?
So you're asking about the word tolerance?
Yeah. They have it as used in the establishment law.
Sure. So the word tolerance has an interesting history for the United States and the Western world. John Locke was the first one who writes this essay on tolerance. It's called On Tolerance. And he made the argument that different religious groups should be tolerant of one another, and even the favored group by government should be tolerant. Except he didn't want Protestants. What he meant was different Protestant sects should be tolerant of other Protestant sects. He didn't think Protestants needed to be tolerant of Catholics, and he didn't think Protestants need to be tolerant of atheists. Okay, and what he meant there was more a definition of showing empathy and respect and allowing them to live in the same society.
So it's a central hegemonic discourse in the way that there is one dominating power, giving others liberty and freedom of speech and thought, whatever.
Correct.
The third question is if I'm
but hold on, I'm not finished on tolerance. So, by the time we get to the founding of the United States, George Washington sends a letter to a group of pacifists among the, it wasn't the Amish, but it was one group of pacifists. And he explicitly tells them, the word tolerance has fallen out of favor, is what he tells them. Okay, he says, we no longer think in terms of tolerance. All these religions must be treated equally under the law. There is no one hegemonic group that will be tolerant of another. Specifically, tolerance, the idea of tolerance had formed the foundation for protecting the free exercise of religion, right? So if one group gets to proselytize on the street to others, then everybody must be able to proselytize, right? There's no longer a favored group that just tolerates everyone else. That idea, by the time of the founding of the United States, had become quite negative. And instead, all religious groups and traditions were to be seen as equal in the sight of the law, and then they could certainly convert one another and debate with one another about who was superior, but the law and the government should stay out of it. So that word tolerance is kind of disfavored now in constitutional discourse in the United States, because it suggests that one group is superior to another, or one group has kind of hegemonic authority, as you say, and that doesn't exist anymore. And your third question?
Yeah, the third question is with regards to the lawsuit that the Muslim police officers made in Millward, New Jersey, near Anecdote. So I was wondering with regards to the the establishment law clause, and in the case of neutrality and applicability. Did it happen that they show the case of already a demonstrated set example preceding one, so that it made the medical condition and the deformity of the skin as a proof for themselves? Or would that happen hypothetically had there been no existing proof like this before? Just in theory, they would argue, litigating for this. Like,
So let me be clear. First, let me be clear. The Establishment Clause played no role in that case. It's only the Free Exercise Clause that. Okay. And let me be clear about that. So the Free Exercise Clause relates to how people live out their religion, how they exercise their beliefs, the actions and the non-actions they choose to take because of their religious beliefs. And so, you know, in the United States, it would be considered burdening the free exercise of religion to force someone to shave if their religion says not to. It would be a burden on the free exercise of religion to prevent people from wearing their religious clothes, hijab, anything, right? It would be a burden on religious exercise to prevent people from proselytizing in the street or from speaking about their religion or teaching it. All these different examples, right? It would be a burden on religious exercise to force someone to do something against that they don't want to do because of their religious beliefs.
Yeah.
So all of that relates to the Free Exercise Clause, and the Establishment Clause is separate. Now, Free Exercise Clause, to get to your question directly, did I understand you? You're asking, could the Muslim men have brought the claim even if there wasn't a medical exception?
theoretically, just exercising like green gymnastics of hypothesis and making it free room of all liberty.
Sure. Was the in your hypothetical, is the policy written in place that would allow for the medical exception even if it's never been used? Is that what you're saying?
Not necessarily written. Or you can argue for, or you can explain on both.
So let me say,
Yeah.
if the policy for the medical exception was written down, then I think the Muslim men would still win.
Okay.
They could just point to it and say, that's there, we win,
Oh.
right? And they probably would win. If a judge understands it. If it's not written but it's being applied, they would still win.
Okay.
Okay? If it's not written and it's not being applied, and there is no exceptions anywhere, then they might lose. Then that would be considered generally
So
applicable.
the de facto discretion actually determines the situation in most cases from your observation.
Well, one thing the court has made, this is interesting, to give you a sense of the religious diversity in the United States, I'll tell you another fascinating case that fleshes this out a little bit. So there was, and the case I'm about to tell you about stands for the proposition that judges must look at how a law is being applied in practice. They cannot simply look at the text. So there was a case in 1993 called Lukumi, L-U-K-U-M-I, and it involved animal sacrifice. So there was an there's an Afro-Caribbean religion, and they're called, the religion is called the Santeria. They developed in the Caribbean, and then some of them moved to Florida to a city called the City of Hialeah. The City of Hialeah sounds exotic, but it's just a big party beach town. It's right next to Miami. It's big condos on the ocean, right? That's where people go play. And this religious group was there, and they had various rituals where they would kill chickens and other animals as part of their religious ritual. Now, they didn't kill these chickens in a violent way. Usually they would do their ritual and then they would cook them and eat them. Okay? But the city of Hialeah did not want to be known as like the animal sacrifice capital of the United States, right? So they passed a law that said no killing of animals within the city limits. You can't kill animals within the city limits, and they passed this law. Now there was all sorts of embedded and hidden exceptions to the rule. But on the face of it, it looked like you can't kill animals in the city of Hialeah. Well, a University of Texas law professor brought a lawsuit challenging the law, and they lost in the lower court. They lost unanimously in the appellate court. He won unanimously in the United States Supreme Court.
So the law was abolished?
Well, what he showed was that there was this rule written down that says no killing of animals. But if you actually looked at the practice, if you looked behind the text and you looked at the practice, they had accepted out pest control, they had accepted out hunting, they had accepted out restaurants, they had accepted out
Eating
veterinarians.
the meat.
Turns out that the only group it applied to was this one religion, right? And the Supreme Court said, judges, you have to look behind the text, you have to see how it's being applied, and that's how you determine if a law is generally applicable. Good question.
Excellent. Yes, come on.
My question is about Irish people.
Irish?
Amish, sorry.
Okay.
Does the Supreme Court has any different interpretations about this group's practices?
No. They're treated the same as any other group. And I actually worked on a case for the Amish. So I don't know, forgive me if you all know this and I was the only one who didn't, but I never understood until I helped the Amish what their religious beliefs were regarding technology. I always thought that they had picked a point in time and they had just said no technology past this point in time.
Freeze the time.
But that's not what they do. What the Amish do is every time a new technology comes to a particular group of Amish, they ask, will this technology change our spiritual way of life? That's the question they ask. And if they say yes, then they will not adopt it. If all of the adults over 18, men and women, unanimously agree that it won't change their spiritual way of life, they will adopt it. So to give you an example, when battery-powered flashlights came out, this one group of Amish in Minnesota agreed to adopt them because they didn't feel like there was any practical difference between a flashlight and a lantern. It wasn't going to change their spiritual way of life. Several years later, when the head strap flashlights came out, they got together and they met, and all of the women said, this will change our spiritual way of life. Right now, our children as young as 2 years old can go out there and hold a flashlight when people are working in the dark, and they're a part of the community. It is helping them grow spiritually. They have useful tasks. If we adopt this technology of the headlamp, those young children won't have anything to do anymore, and they'll just be off playing. It's going to change their spiritual growth. So they rejected that technology. Does that make sense? So we recently worked on a case for the Amish in Minnesota. I'm very proud of this case, but I'll tell you why later. In this case, a county in Minnesota was trying to force the Amish to use septic tanks for their sewage. And the Amish voted against doing it. The county tried to force them to use the technology against their religion. They filed a lawsuit. It went all the way up to the U.S. Supreme Court, back down, back up again to the Minnesota State Supreme Court, and then there, a new attorney came in for the state government, and she called us up one day and she said, you know what? We could have worked with your clients from the beginning without burdening their religious exercise, so we're going to drop the case and pay your attorney's fees. Wow. Gives you a sense of how these things work sometimes. The reason I'm proud of that case is I do believe in religious freedom for everybody, and I had a number of students working on that case. I had a Catholic, a Protestant, a Latter-day Saint, an atheist, a Hasidic Jew, and a Muslim, all working together on behalf of this little understood religious group in the wilds of Minnesota. And for me, it was good to see them all working together like that, not committing the Puritan mistake. So.
Okay, last question.
Maybe the ladies would like to
Maybe just a open-ended question. Is it okay, Seifi? I'm a researcher also here, and just next to this floor. Of course, separation of church and state is one of the indispensable articles in the U.S. Constitution, and sometimes the relationship between politicians and religious denominations may vary. And how is it going in these days is it getting better or is it getting worse? Interference, especially politics or politician interference of the religious relations.
So it's very much a state-specific question, and it's very much in the eye of the beholder. I will tell you that the words separation of church and state do not exist in the Constitution. In fact, the only reason they're there is because Thomas Jefferson wrote a letter to his wine supplier saying that there should be a separation of church and state. Well, he was writing a letter to his wine supplier about religious freedom. He wrote another letter to a group called the Danbury Baptists, and he said there should be a separation of church and state, a wall of separation. That was never in the Constitution. It was forgotten about until 1879, so almost a century, when a Supreme Court justice found the letter and put it in an opinion. Then it was forgotten about again for 50 years until 1947, when the Supreme Court again quoted this line. It has become this kind of mythical phrase that we use that has no grounding whatsoever in the Constitution. So it has the notion of separation of church and state has largely now been abandoned for legal analysis. It's still there as a myth and folklore, but it's been abandoned for legal analysis. Now the question, of course, is how much is religion entangled with government, right? You know, there are groups that would love to do it if they could. There are groups that would love to force their religion into law and push it upon people and coerce their religion. There are groups that would love to prevent that from happening at all costs, so much so that they would rather force secularism on people. And I think by and large, most people in the United States would just prefer a world where government is not forcing any one religion and it's not forcing secularism. It's just letting people persuade, convert, proselytize to one another freely without the interference of government. And I think most people are in that camp, but there's no question there's groups on each end that would prefer to push religion into law if they could. Does that make sense?
No.
Yeah.
Right.
Okay, thanks so much, Steve.
There's a woman.
Okay, yeah, yes, please, thank you, yes. Thank you.
I'm so sorry for the late question, but I want to ask you about the church and state. It comes to my mind when you say church and state. So there was a religious movement, maybe hippie also. You know that. How can we locate this scandalistic religious movement? Maybe we can say hippies in those kind of concepts.
The hippies?
Yeah, no. The Oslo. Do you know Oslo?
I don't.
The new religious movements.
Osho.
I don't think I know. So we're asking how a new religious movement.
Very strange religious movement.
What's Osho again?
Documentary. Indian
Religious leader or teacher or just leader.
Okay.
I think this guy.
And so maybe, so like, how do we take kind of New Age religions and how do they fit into the conversation? Yeah. This gets to the problem of not having a definition for religion, right? So new groups come, and new religions regularly are born and come to life. And what judges have to decide is, am I dealing with a religion? Am I just dealing with a philosophy? Am I dealing with just kind of some new age weird movement that shouldn't be considered religion, right? Usually what the court will do is what courts will do is they will feel incredibly ill-equipped to define if something is a religion. So they won't answer that question. But if they don't think something is a religion, they'll find a way to rule against them. Does that make sense? So some new group might come along and claim that they should get protection, and a judge will just say, well, I'm not even going to go into the question of whether you're a religion or not. I'm just going to say you lose because I don't think your exercise of religion was burdened. They avoid the question. Occasionally, there are some courts that will answer the question, and where we see this in the United States is in prisons. There are gangs in prisons in the United States that are white supremacist gangs, and they will claim that they're they have a theory of white racial supremacy, and they will claim that they should get religious freedom protections for their white racial supremacy. And there are a number of courts who have rejected that claim. They have said, we just don't think you're a religion. Now, interestingly enough, if you really look at what the people are claiming and how we've treated religion, they probably are a religion and should lose for different reasons. But some courts have been bold enough to just say, I'm not going to count white supremacy as a religion. So.
Any final thought or comment?
Thank you so much for having me.
Again, thanks so much, Professor Collis. It was wonderful. Thank you. So Professor Collis is going to be here for a few minutes.